The rule was adopted earlier this year, and actually it's the result of lobbying by one of our largest newspapers, the Ledger, and its attorneys to try to have our court pass some type of rule that would give notice of applications to seal and the like. And has finally adopted, the rule is a procedural rule. It's not intended to supplement any existing statutes or other regulations or the like. For example, Federal Rule of Evidence, I believe it's 612, requires in-camera proceedings and the like, or allegations involving sexual conduct that might be coming up during a trial or the like. But the rule is also intended to reflect Supreme Court and Third Circuit law. It deals with all aspects of confidentiality and sealing that a court addresses. So it addresses confidentiality orders governing discovery, sealing orders that would allow materials to be filed under seal or proceedings to be sealed, and it's also intended to address the sealing of settlements. What's innovative about it, number one, is it's comprehensive and it deals with all of these areas of confidentiality and sealing, and number two, it's tied to electronic filing. David was mentioning before the fact that all the district courts, bankruptcy courts, and soon the appellate courts are going to be going on to electronic filing. The district court's filing system is called CMECF. And what our local rule does is tie everything that might be filed under the rule to a specific designation or event. So when a motion is made, it's designated a certain way, and that'll show up on a daily report or an instantaneous report that's available on the PACER site that people can subscribe to by identifying themselves, basically, so that someone can have remote access to any type of applications that may be filed to sealed proceedings or sealed courtrooms. And this entire idea is, number one, to give public notice, and number two, to be consistent with the idea of an opportunity to be heard. The rule speaks through it of the possibilities of parties to intervene. Our Third Circuit has told us that the intervention mechanism is 24B, which is permissive intervention, and the rule recognizes that. The rule applies to applications in addition to discovery orders, applications to seal any type of papers, as I said, any type of proceedings. Also, it addresses anything submitted to a judge or anything pertaining to a judge that's substantive in nature as opposed to discovery in nature. It addresses the discovery orders. It recognizes that there's no right of access to unfiled discovery materials. It also recognizes that blanket protective orders are allowed, which our Third Circuit allows us to file, to sign on a showing of good cause. And as I also mentioned, it addresses trials and it also addresses settlements. So that if there is an application made to file a settlement under seal, the rule talks about that. It also talks about dockets. It states as a general proposition that we will have no sealed dockets in the district unless it's required by law. And the example of that are the key TAM provisions of the False Claims Act provide for sealed dockets for a certain period of time. And it also provides that specific docket entries can be sealed on a motion, just as you would seal a filing with the court or a court proceeding. You can file a specific docket entry if you make an application to do it. So throughout the whole rule is this concept of adequate notice and opportunity to be heard. And that, in a nutshell, is Rule 5.3.
Have any challenges been made yet under the rule?
No. As a matter of fact, I talked to the reporter from the Ledger who his paper was responsible to it, and all he sees are applications pertaining to patent cases. And I have not seen much interest in that, one way or the other.